After becoming the victim of a crime, I was quick to take action to discover what my rights were and what I needed to do to exercise them moving forward. I contacted the Victims of Crime Resource Center, and they gave me all the information I needed to request my constitutional rights once an arrest was made. A few days later, the detective from my case called to inform me that the suspect had been arrested. I was thrilled. I recalled the information that the VCRC counselor had provided me about how to request my rights, so I contacted the district attorney's office and followed those steps. One of the rights I requested was the right to be notified, but when they contacted me, I wasn't ready for what I was going to hear. Hello?
Hi, this is Trevor Phillips at the district attorney's office. May I speak with Molly?
Yeah, that's me.
I'm calling today in regards to the incident that took place on the 15th of last month. We received your request to remain informed about the case moving forward. I was calling today to let you know that the DA's office will not be filing criminal charges in this case.
Wait, what? What do you mean you're not filing criminal charges?
Well, after examining the evidence, we just don't feel like we have enough to prosecute.
But I'm pressing charges. Aren't you supposed to file charges if I say I want charges filed?
The truth is that once a crime is reported, it is completely within the discretion of the district attorney's office to make that decision. In your case, we chose not to file charges for many different reasons. The main reason being that we don't have enough evidence to get a guilty verdict in court.
But I want charges filed. Isn't the DA supposed to be representing me? How can you just ignore my wishes? I was the victim. And how am I supposed to get restitution if you don't file charges?
I understand how you feel, and I know that this isn't easy to hear. The truth is that we represent the state of California. You do have the option of hiring your own attorney to represent you in civil court. But remember, your Marsy's Law rights only apply to the criminal justice system and not civil matters.
What good is that going to do for me? You already said that there isn't enough evidence to convict. What difference does it make if I file in civil court?
Civil court has a different burden of proof than criminal cases do.
Different burden of proof? What does that mean?
I'm sure you've heard the phrase beyond a reasonable doubt, and that is the burden of proof for a criminal trial. We need to prove, totally prove, that the defendant is guilty to a jury. But in civil court, the burden of proof is much lower. It can be described as more likely than not.
More likely? I don't get it.
So, in a civil trial, your attorney would prove that the defendant is more likely than not responsible for your losses.
All right, then what should I do then?
Your next step is to contact your county or state bar association lawyer referral line, and they can put you into contact with an attorney that specializes in this type of law.
All right, then that's what I'll do. Thanks for the information.
No problem. And again, I'm sorry that we cannot pursue this matter any further. I wish you luck in the future, and I hope you have a good day.
Yeah, fine, you too. I was angry. Angry that I wouldn't get to see that jerk punished. But at least I did have a way of moving forward.